Good morning, friends. Today we will see the defense of mistake. The defense of mistake has been incorporated in section 76 and 79. If you see section 76, it says nothing is an offense which is done by a person who by reason of a mistake of fact and not by reason of a mistake of law in good faith believes himself to be bound by law to do it. On the other hand, section 79 provides protection. Nothing is an offense which is done by any person who is justified by law or who by reason of a mistake of law in good faith believes himself to be justified by law in doing it. 76 and section 79 both together incorporate an English common law maxim: ignorantia facit excusat, ignorantia juris non excusat. Ignorance of fact is excusable, but not the ignorance of law. Now, the question arises, what is mistake? In English law, the term ignorance is used. Under Indian law, the term mistake is used. The defense, in fact, is based on the absence of mens rea on the part of the doer due to mistake. Because of mistake, faulty mental condition does not exist which justifies that such person should be exempted from criminal liability. The question arises, what is mistake? Mistake is an error. In fact, mistake is an erroneous mental condition, conception, or conviction induced by misapprehension, ignorance, or misunderstanding of the truth. As a result of this, some act or omission is suffered erroneously by one or both of the parties to the transaction. Both parties or the party does not know about the erroneous character of the transaction or what kind of error has been committed by him is not known to him at the time of doing the act. Now the question arises, what is a mistake of fact? Because mistake is of two types, mistake of fact and mistake of law. Once we know that what is mistake, now the question arises, what is mistake of fact? Mistake of fact consists in an unconsciousness, ignorance or forgetfulness of a fact, past or present. The person believes in the existence of certain thing which has not existed or is not existing at present. Secondly, the person believes in the non-existence of a certain thing which actually exists. And therefore, mistake of fact means mistake with regard to a fact. Now the question is, what is fact? Fact is a real state of things as distinguished from imaginary things, conceptions. Mere mistake is not sufficient to secure exemption from criminal liability. The mistake must be genuine and mistake must be reasonable. Genuine means the mistake must be in good faith. There must have been some proper inquiry which has been made by the person, and the mistake must be reasonable. It is not imaginary. Remote conviction. This should not happen. And therefore, it has been said that the mistake must be genuine and mistake must be reasonable. Now the question arises, what is mistake of law? We know what is law. Now mistake of law again may be of two types. Mistake about the law. The person does not know the law. Secondly, the mistake may be on the basis of calculation made about the legal effects of the transaction. There may be the mistake with regard to this. Similarly, there may be mistake about the misapplication of law. That is also mistake. And therefore, mistake of law is difficult to be established on the part of the prosecution, and hence it has not been allowed as a defense. Mistake of law is not allowed as defense because of expediency and public policy. These things will be seen a little later. Now we come to some points. If you see the first illustration attached to section 76, it says that a soldier fires at a mob by the order of his superior. If the order is in conformity with the law, A has committed no offense. In this illustration, you will find that there is no question of mistake, there is no question of belief that the person believed in good faith, that he was bound by law. Here, simply is that if the order of superior is in conformity with the law, the person is bound by law to do it, and therefore he will be exempted from criminal liability. So section 76 in fact consists of two parts. First, where the person is bound by law, and secondly, where the person believes in good faith that he is bound by law to do the act. The Supreme Court for the first time pointed out the distinction between these two parts of section 76. In Shew Mangal Singh, on the orders of the Deputy Commissioner of Police, a patrol party opened fire on a dark night, as a result of which 2 persons were killed. The Supreme Court held that the prosecution did not succeed in proving the case against them. The order of the superior officer was lawful, and therefore there was no question of proving the mistake, good faith, etc. The order of the superior officer was perfectly within the conformity of law, and therefore the first part of the section was applicable, that the person was bound by law to do it, and there nothing else has to be proved. We may take second case where again the same question arose. This was Charan Narain Singh. In a tent, gambling was going on. No violent mob had assembled. A constable, in obedience of the order of superior, fired inside the tent and shot a woman dead. It was held that the constable was guilty of murder because the order of superior was illegal, which could be lawfully refused by him. These two cases establish one point, that if the order of superior is lawful, then the person has to prove nothing except he is show to the order in the defense, and he will be exempted from criminal liability. But if the order is illegal, then the protection does not extend. But This is a very piquant situation for a person. If on the field he starts making inquiry whether the order is lawful or unlawful, during that period he himself might be killed by someone, by the criminal. And if he fires, kills the person, and the order is not lawful, he is guilty of murder. So, and secondly, even if nothing happens, if he refuses the order on the ground that it is unlawful, the question before the court will come late. In beginning, departmental inquiry will be there, indiscipline would be inquired. So here the officers who act on the orders of the superiors face a piquant situation. Station attached to section 76 explains where the requirements of belief and good faith become important. Section 76, second illustration. An officer of the court is ordered by that court to arrest Y. After due inquiry, believing Z to be Y, arrests Z. A has committed no offense. Both the requirements of section 79 second part are complied with. Good faith, belief. Hence, no offense has been committed by him. Section 79 deals the situation when the person is justified by law. Again, there is one illustration which explains what is justified by law. A sees Z commit what appears to A to be a murder. A, in the exercise of best of his judgment, exerted in good faith, seizes Z in order to bring him before the proper authorities. A has committed no offense, though it may turn out to be that Z was acting in self-defense. Even if Z was acting in self-defense, A is not guilty of any offense. 9. It is necessary that the act must be done in good faith. The term good faith has been defined in section 52 of the penal code, and it means proper care and caution. If the act has been done with proper care and caution, it is said that the act has been done in good faith. In Bhawoo, Jivaji versus Mulli, Dayal, a police officer saw a person in early morning carrying 3 pieces of clothes in his arm. He put certain questions to him. The answers were not satisfactory. He arrested that man. Later on, it was found that the pieces of clothes were not stolen one, and then that man charged the police officer for wrongful restraint and wrongful confinement. The court held that since proper inquiry was made, due care and caution was taken, so the act was done in good faith, the defense was allowed. In Shew, Suran, Sahai versus Mohomad Fazal Khan, the defense was not allowed. What happened that a police officer saw a mare tied up in these premises. Few days back, the mare of his father had been stolen by someone. He thought that it was that mare. He inquired from D, thinking that either he had stolen that mare or he might have purchased it from the thief. He came to know that he had bought it from P. Then he charged P for the offense of theft and compelled him to give bail. During this process, he did not inquire from his father whether it was his mare or not. It turned out to be not the mare of his father. The court held that the defense of mistake was not